Judgment in the matter of the Crown on the application of Maguire against His Majesty's Senior Coroner for Blackpool and Fylde and another.
Lord Sales will explain the court's judgment.
This case is about an inquest into the death and tragic circumstances of Jacqueline Maguire, whom I will call Jackie. Jackie was aged 52 and had Down syndrome. She lived in a residential care home for adults. In order to ensure she could be kept at the home under proper supervision, she was subject to a Standard Authorisation for deprivation of liberty made under the Mental Capacity Act 2005. On the 21st of February 2017, Jackie became very unwell. Her GP advised some treatment, but this did not help. Eventually, the care home called an ambulance. Their paramedics made an assessment of Jackie and spoke to the out-of-hours GP. Jackie was responsive, but she was resistant to being taken to hospital. It was agreed that it would be desirable for Jackie to go to hospital for tests. However, the paramedics and GP did not think her life was at risk and did not think that it was critical to take her to hospital. In the circumstances, the paramedics' assessment was that the use of restraint to take Jackie there against her will would not be justified. Therefore, she was left at the home to be monitored by staff through the night. The next morning, Jackie suffered a serious collapse. The care home again called an ambulance, and this time Jackie was taken to hospital. At the hospital, it was discovered that Jackie was suffering from pneumonia and a perforated gastric ulcer and peritonitis, which were now at an advanced stage. If brought to hospital on the 21st of February, she could have been treated effectively. But on 22nd February, it was too late. Jackie died in hospital that day. An inquest was held into Jackie's death by a coroner sitting with a jury. The legal issue which arises in this appeal concerns the form of the verdict which the coroner invited the jury to give at the end of the evidence. The standard verdict to be given in an inquest simply records how, when and where a person came to die. That was the form of verdict which the coroner directed the jury to give. In line with that direction, their verdict was a simple one, that Jackie had died by the natural causes I have mentioned. However, in certain circumstances, Article 2 of the European Convention on Human Rights, which concerns the right to life, has an impact on the form of verdict to be given at the end of an inquest. In the cases where Article 2 requires that for particular reasons the state has an enhanced obligation of investigation into the circumstances of a death, the verdict which should be given takes an expanded form. This is what Section 5, subsection 2 of the Coroners and Justice Act 2009 provides. In those cases, the verdict has to include a wider examination of the circumstances which culminated in the death, which may involve findings about the conduct of the relevant authorities and about the care provided. Jackie's mother, Mrs. Muriel Maguire, who is the claimant in these proceedings, has brought this judicial review claim to challenge the coroner's direction to the jury. She maintains that this is a case in which the enhanced obligation of investigation applied under Article 2 of the Convention, with the result that the coroner should have directed the jury to give an expanded form of verdict. Accordingly, the appeal is about the effect of Article 2 in Jackie's case. The High Court dismissed Mrs. Maguire's claim. It held that the coroner was right to direct the jury to give a standard verdict. The Court of Appeal dismissed Mrs. Maguire's appeal, and she now appeals to this court. The Supreme Court unanimously dismisses the appeal. I give the leading judgment with which Lord Reid, Lord Lloyd-Jones and Lady Rose agree. Lord Stevens gives a concurring judgment. As well as containing a prohibition against the taking of life, the Court explains that Article 2 imposes an implied positive obligation on the state to take appropriate steps to safeguard the lives of those within its jurisdiction. The positive obligation has two substantive aspects. First, there is a systems duty according to which the state is required to ensure there are appropriate legal and administrative systems in place to provide general protection for the lives of people in its territory. Secondly, there is an operational duty according to which operational steps must be taken to protect a specific person when officials or others are on notice that he or she is subject to a risk to life of a particularly clear and immediate kind. The positive obligation under Article 2 also has procedural aspects regarding the investigation of a death and the provision of an opportunity to call state authorities to account for possible breaches of the substantive positive obligations. The precise content of those procedural obligations varies according to context. First, at a basic level, the authorities have to take steps to establish whether the cause of death is from natural causes or from violence. Secondly, in particular contexts, such as where a death occurs in prison, the authorities may be required to take further steps to investigate possible breaches of the Article 2 substantive obligations on the part of officials and others to ensure accountability and redress and, as appropriate, to punish persons responsible for the death. It is only if this enhanced procedural obligation applies that a coroner may be required to direct an inquest jury to give an expanded verdict. Thirdly, even if the enhanced procedural obligation does not apply, but there is still a possibility that the substantive obligations in Article 2 have been breached, there is an obligation to provide means by which a person complaining of such possible breaches can make that complaint and have it investigated or obtain redress, such as in the form of an award of compensation to the family. Jackie's death occurred in a care home and healthcare context, very different from a prison, so the enhanced procedural obligation did not apply automatically. Instead, whether it applied or not depends on whether there was an arguable breach of the system's duty by the care home or by the healthcare professionals in the case, or an arguable breach of the operational duty by those persons. The court finds that, by the time the coroner gave his direction to the jury, after the circumstances of Jackie's death had been examined in detail in the evidence at the inquest, he was entitled to conclude that there was no arguable breach of either the system's duty or the operational duty for them to consider. Therefore, the coroner was right to direct the jury to return a standard verdict. So far as concerns the system's duty, the evidence was that the care home, the ambulance service and the other healthcare providers had systems in place which were capable of operating in a way which was effective to safeguard Jackie's life. The fact that there may have been particular misjudgments or lapses by individuals involved in operating those systems does not show that the systems themselves were defective. So far as concerns the operational duty, the evidence showed that the care home called the ambulance when they realised that Jackie might be seriously ill so that her life could be in danger. In that way, in relation to a vulnerable individual like Jackie who could not care for herself, the care home secured access for her to the healthcare services available to the general population. This was the appropriate action for it to take and was all that was required. Having done that, the care home was entitled to rely on the medical judgment of the paramedics and doctors involved. The paramedics and the doctors investigated Jackie's condition on the evening of 21st February and reached the view that her life was not at risk. They were not on notice of an immediate risk to life, which would be the basis for the operational duty under Article 2 to be triggered. They made a tragic mistake. But the mere fact that someone dies as the result of a tragic mistake made by a healthcare professional who is not aware that their life is in serious danger is not something which brings the enhanced procedural obligation into operation. As regards the other aspects of the positive procedural obligation, there had been a careful examination before and in the course of the inquest of the immediate cause of Jackie's death, and the legal system provided the opportunity for Mrs. Maguire to seek redress, if she chose, by bringing legal proceedings, claiming that the care home or the healthcare professionals had been negligent. As a result of this analysis, the court concludes that there was no legal error by the coroner in directing the inquest jury to return a standard form of verdict.